Hello there, and welcome to this week's Beresford Booth webinar. I am JP Diener. I'm going to be telling you today about trust and estate litigation and why it is so special. The world of litigation, which is essentially court and arbitrator resolve disputes among parties over various types of topics and areas of the law. Litigation is broad, it's big, there's a lot there. But in Washington and in most states and throughout the country, litigation, regardless what it's about, contracts, real estate, what have you, it goes through the same procedural process as all other litigation. There are procedural rules specifically for litigation in superior courts and in other types of courts within Washington. But all litigation falls within those rules. One exception to that, however, is when it comes to estate and trust litigation. Disputes often arise in the areas of estates and trusts. People like to fight over, grandma's will. They like to fight over mom and dad's trust. There are a lot of issues that can come up in estate and trust management and administration, and a lot of disputes arise for a variety of reasons. And there's so many disputes in that world that the Washington legislature actually created a statute specifically to deal with trust and estate litigation. And they call it the Trust and Estate Dispute Resolution Act. It is one of the few areas that gets its own real dispute resolution process. And so it's special, it's a unique area of the law, at least procedurally, when it comes to resolving those disputes. You can find the TEDRA Act in the Revised Code of Washington under Title 11, Chapter 96A. The whole thing is dedicated to estate and trust dispute resolution. And the act itself is designed to settle all matters concerning the estates and assets of incapacitated, missing, and deceased persons, including matters involving non-probate assets and powers of attorney. So trust and estate dispute resolution is itself pretty broad. There's a lot that can fit within that. It's not only deceased persons. It's not only the estates of deceased persons. It can be the estates of missing or incapacitated people that have disputes and need some kind of resolution. Within TEDRA, the court is given very broad powers to administer and settle the estate in any manner and any way that the court deems right and proper. And that's language directly from the statute. The goal of TEDRA is to ensure that the dispute is resolved expeditiously and settled by the court. So they give the court lots of power to get the dispute settled, more power than you would get just in regular litigation. So TEDRA is really all about expediency and working to serve the best interests of the estate or the trust. The statute itself takes precedence over all other civil matters, over the civil rules of regular litigation. So wherever the civil rules for regular litigation differ from TEDRA, TEDRA controls. Let's say you have a probate. You would if a dispute comes up within the context of that probate, the TEDRA Act requires that a party file a brand new action, a TEDRA lawsuit outside of the probate. Now that can eventually be joined back to the probate, but you create your own act or your own litigation specifically about that dispute, whatever it may be. So you file it as its own case. It requires a special form and it requires a special answer. In most litigation, you answer a complaint within 20 days of receiving service of that complaint. In TEDRA, however, When you file what's called a petition, we don't call it a complaint, but it's the same thing. When you file a TEDRA petition, you also set the initial hearing on the matter. And that initial hearing can resolve the entire case. Now, this is very different than regular civil litigation where you file the lawsuit and you may not get a trial date for months or years down the line. When you file that TEDRA, you have the option to immediately note that hearing. And that hearing can take place, I think 21 days is the date, 21 days after you file and serve the TEDRA petition. And the other party doesn't have to respond to that TEDRA petition until 5 days before that hearing. And that hearing can actually resolve every single issue. So you can get your trial within 21 days of filing your petition. Like I said, TEDRA is all about expediency. The legislature and the courts want to see disputes related to estates and trusts resolved quickly, because the longer disputes linger in the case of an estate or a trust, the estate and trust is not being administered. So the beneficiaries are not getting the benefit of that trust and estate. And the focus of the administrator of that trust or estate is on the dispute. And so courts and legislature recognize that we need to get these things resolved as quickly as possible. So that is the goal. You can go in, you can have your initial hearing with just a few weeks of filing your petition, and you can get a resolution. Not always is the party filing the petition ready to get a resolution that early. Sometimes you do need to go through a discovery process. Sometimes you do have to depose other parties, get documentary evidence, go through your investigation. So sometimes that initial hearing is not actually going to be the trial on the whole thing. But you can still have that initial hearing at which you would set a trial date. Again, even in that instance where you're not resolving everything at the initial hearing, you can still get a trial date much earlier than you can in regular civil litigation. You can set up a discovery schedule. You can address certain issues, but not all of the issues in the petition. So you can address some of the things about the dispute and save other things for later. That is one of the unique and interesting aspects of TEDRA, is just how quickly you can potentially get through stuff. Now, it doesn't always work out that way. I mean, I have seen TEDRA cases that have dragged on for years. So don't go in just assuming you're going to get this resolved. But TEDRA gives you at least a framework that if all the parties agree to get this resolved sooner rather than later, you can actually do it. In a regular civil litigation, even if the parties want to get it resolved, you're at the mercy of a court schedule, you're at the mercy of a number of different things, and you cannot always guarantee a quick settlement. But if all the parties are on the same page and they're ready to get something resolved in a TEDRA proceeding, that can actually be done quickly. And that really is the primary focus of what TEDRA is all about. You can have a jury within TEDRA. It doesn't have to be a bench trial. Typically, TEDRA cases are bench trials, meaning that a judge decides the case. That's typically what happens, but you actually can ask for a jury. So if you want a jury and you're asking for something other than equitable relief being asking somebody specifically to do something as opposed to pay some money, then you can get a jury. If you're asking for money, if you're asking for some party to pay another party money, you can get a jury. If you're just asking for them to, turn over Aunt Petunia's Camaro because it should be in the trust, you're not going to get a jury on that, because that's an equitable issue. One of the other cool things about TEDRA, and one thing that makes it different, is that it highly favors alternative dispute resolution. And when I say alternative dispute resolution, I mean mediation and arbitration. You can do mediation in pretty much any type of litigation. But in TEDRA, you can force mediation by demanding. And in order to get out of mediation, the other party has to show the court good cause that mediation is a bad idea. And that can be pretty difficult to do. Courts are very supportive of seeing the parties go into mediation. And mediation, just so you understand, is the idea that you go in with a neutral third party who tries to help you come to a solution. It tries to help both sides come to a resolution of the case. It's not a decision on the merits. It's a non-binding situation until you enter into a full settlement agreement. But it helps the parties resolve it. And in TEDRA, you can demand mediation at any time up until the final trial. The 3 days, I think, before the trial, you can still demand mediation. And that forces the parties to get together and talk about how they can settle it. If mediation is unsuccessful, then TEDRA allows you to demand arbitration. So if the other party, doesn't want to do mediation, or if you try mediation and it fails, then you can force arbitration. And arbitration is a little bit different than having a full-on trial, because it is fairly narrower in the scope of the procedure that occurs, and it tends to be a little bit quicker. If the judge's schedule in the TEDRA case is tricky and you're not actually able to get into a trial as soon as you would like, arbitration can be good. There's a number of reasons that arbitration can be good, but it's different from regular civil litigation, because not every case in civil litigation is subject to arbitration. Unless both parties agree, again, you can't get arbitration in every civil litigation. But in TEDRA, you actually can. You can force that issue, but you have to try mediation first, unless the court has ruled that mediation is pointless. So again, a cool aspect of TEDRA is that you can really force an early settlement or an early resolution through arbitration. So what are the reasons you would use TEDRA? Yes, I'm talking about disputes, but what type of disputes are we really talking about here? You can use TEDRA if you're the personal representative for an estate, for example, and you're uncertain about how to proceed on an issue. You don't know what to do about Aunt Petunia's Camaro. You're not sure if Aunt Petunia's Camaro really is a part of the estate, or maybe somebody else might have an interest in it. And you can go to the court and you can ask for instruction as to what to do with Aunt Petunia's Camaro, or whatever else is troubling you as the personal representative of the estate. You don't need another party to come in and make a dispute. You can just say, hey, court, I need direction on what to do with this thing. I don't want to get in trouble. I want to make sure I do it right. And so you, as the personal representative of the estate, you can file a TEDRA and a request for instruction. And the court will look at the evidence, will look at what you're telling the court, and the court will give the direction to the PR. That can be done within a TEDRA. Somebody's contesting a will. Somebody is saying, hey, this will is bogus. This is a totally fraudulent will. Or, hey, this will is not valid for any number of reasons. So a will contest, that could be done through a TEDRA. You're a beneficiary of the estate and you're not happy with what the personal representative has done. Maybe the personal representative has let the estate go on too long, hasn't marshaled all the property, hasn't brought it all into the estate. Maybe they've been self-dealing. Maybe the personal representative has been writing themselves checks from the estate account so that they can, go to Disneyland or something. In any case, you think the personal representative, or in the case of a trust, you think the trustee has not been playing fairly, you can sue them for a breach of their duties. That also would be within the course of a TEDRA. So these are areas that you see on a regular basis within TEDRA, whether it be requests for instruction, whether it be will contest, whether it be challenging a trustee or a personal representative based on breach of their fiduciary duties. A lot of things going on there. Speaking more about will contest, there are a number of reasons why you might contest the will. You might say it doesn't meet statutory requirements. You might say that the person who executed the will was unduly influenced to make that will. Undue influence is a really interesting area of the law. It's the idea that some third party exerted influence over the person who created the will, and they affected their estate planning to the point where they exercised control over the testator's volition, interfered with their free will, and prevented an exercise of judgment and choice. This is a hard area to prove, but the court considers three main factors. The court says, was the beneficiary, the person who received, who is alleged to have done the undue influence, were they in some kind of confidential relationship with the testator, or did they owe fiduciary duties to the testator? If that's the case, if they were in some kind of position of trust and confidence with the testator, it's more likely that the court will find that they unduly influenced that testator to change their will or write their will in a certain way. The other factor too is that the beneficiary, the person accused of undue influence, actively participated in the procurement of the will. That means that maybe they took the testator, the person who created the will, maybe they took them to their own attorney. They said, hey, I have an attorney for you, come on down here. Or maybe they were there while the attorney was going through everything with this person. Or maybe they actually had input. So what role did they play in the actual creation of the will? That's factor number two. Factor number three is, did they receive an unusually large share of the estate? Was the person accused of undue influence, say, a neighbor who would not normally take any part of the estate, but suddenly that neighbor, is coming over every day, takes this person down to the lawyer's office and says, hey, they want a will and they want it to say X, Y, and Z, and they want to give me 75% of their estate. Well, that neighbor would never have received any of that estate. So 75% of that estate is an unnaturally large amount. And so the court looks at that. Undue influence is a very interesting area. It is hard to prove, but it's an area that there's tons of cases on undue influence within the TEDRA context. Lots of lawsuits within TEDRA on whether or not the person who created the will or the trust had the capacity to do so. Testamentary capacity is a real issue, but it's also, I have to say, a very low bar. There's plenty of cases out there and plenty of situations where somebody has had diminished mental capacity. Maybe they've even been diagnosed with some form of dementia, and they're still found to have testamentary capacity. So proving that somebody lacked testamentary capacity to execute a will or a trust is very, very difficult to do because that bar is so low. But if you think that's an issue, you bring it, that's a dispute, and it comes within TEDRA, and that issue gets decided within the context of TEDRA. So that is, in a nutshell, the area of trust and estate administration. There is a lot that can be done within trust and estate administration. I've given you just a few examples so that you understand what types of issues can arise. But if you do have a dispute and it's within the context of a trust or an estate of some kind, you can utilize TEDRA to handle this. And TEDRA really does require some specialized knowledge because it's outside the normal course of basic civil litigation. And if you're going to get involved in a TEDRA lawsuit, if you have an estate issue, where again, even if it's over an incapacitated person's estate, it doesn't have to be somebody who's passed away, or there's some kind of a trust, and maybe all the people with the trust are still alive and still doing their thing, but there's a dispute amongst the people involved in that trust. You need to go to an attorney who understands TEDRA. There's a lot of pitfalls, a lot of areas. Even some courts don't fully understand TEDRA, and it takes a good attorney who is well-versed in TEDRA to be able to explain to a court the differences between the TEDRA litigation and regular litigation, because courts are so set on their regular litigation, and you come in asking for some special relief that you can get in TEDRA and not anywhere else. And the court doesn't always immediately understand that that's available. It takes a good attorney who understands that TEDRA is a special area to come in and explain that to the judge. So if you have that issue, if you have an estate or trust dispute, go to an attorney who really gets trust and estate administration. I do, this firm does, we have a lot of experience in that area, and it will make things a lot easier on you. And if everybody's on the same page with TEDRA, you can get this thing worked out potentially early. At least you have the possibility to do that through TEDRA that you don't have through regular civil litigation. So thank you for joining me for this presentation today. I hope you learned something. I hope you took away something from it that you find valuable. And if you have any questions at all, please feel free to reach out. Thank you.